everyone, welcome back to American Government Politics. In this video, we are going to focus on redistricting Supreme Court cases. This was highlighted in the Article 1 video. So we'll just kind of go over some of the Supreme Court cases or key Supreme Court cases where redistricting in regards to voting was a big issue in those cases. So let's get started. And one of the cases that we will highlight is in regards to political questions doctrine. And basically what that means is that, number one, some matters are committed to the unreviewable discretion of the political branches, which opens up constitutional interpretation, which acts a textually demonstrable constitutional commitment of the issue to a coordinate political department. Two, some legal questions should be left to the other branches as a matter of prudence. And this goes to judicial discretion, which looks to the perception of the lack of judicially discoverable and manageable standards for resolving an issue. So constitutional interpretation is all about strictly looking at the Constitution, what it actually means based on how the founders believed it ought to be, while judicial discretion, it just gives it to the other branches to answer that particular question. So the first case that highlights this is Baker v. Carr of 1962. So a few facts of the case is Charles Baker was a Republican who lived in Shelby County, Tennessee, and served as mayor of Millington, Tennessee. According to the Tennessee State Constitution, it required that legislative districts for the Tennessee General Assembly be redrawn every 10 years according to the census. As you know, in Article 1, the founders believed that we should do a census every 10 years according to the United States Constitution. Well, Baker argued that Tennessee had not redistricted since 1901 in response to the 1900 census. His suit detailed how Tennessee's reapportionment efforts ignored significant economic growth, population shifts within the state. And to your right, this is Baker Carr. So what is the legal issue that was given to the Supreme Court? Well, did the Supreme Court have jurisdiction over questions of the legislative apportionment? Well, the Supreme Court ruled this way. The Supreme Court ruled that when cases that involved a political question, it is found, number one, a textually demonstrable constitutional commitment of the issue to a coordinate political department, or two, a lack of judicially discoverable and manageable standards of resolving it, or number three, the impossibility of deciding without an initial policy determination of a kind clearly for a non-judicial discretion, or four, the impossibility of a court's undertaking independent resolution without expressing lack of respect due coordinate branches of government, or five, unusual need for unquestioning adherence to a political decision already made, or lastly, number six, the potentiality or embarrassment of multifarious pronouncements by various departments on one question. So the law that was referenced in this case was Article 5, Section 4, which is the guarantee clause, which states in the Constitution, the United States shall guarantee every state in this union a republican form of government, and shall protect each of them against invasion and on application of the legislature or of the executive when the legislative cannot be convened against domestic violence. So this section essentially is considered the federal government's guarantee to the states. Essentially, this means that the United States government promises that each state will have a Republican form of government. The United States government will protect the states from invasion as well as from domestic rebellion at the request of a state legislature or state executive, or in our case, the governor, if the legislature can't meet. So, if the legislature of Congress cannot meet, that stuff will go to the states, and you can kind of think of it, as federalism in this case, where alternatively, if the legislator cannot make or Congress cannot make a decision, they'll give it to the states to resolve that particular issue. Now, for your reference, republics are government in which power lies with the citizens who elect officials to represent them and their interests. So this is kind of like republicanism, a law of nature, a social contract where we elect our officials to represent them in order to keep government moving. So there was a dissent in this case by Justices Frankfurter and Harlan, and they stated that appellants invoke the right to vote and to have their votes counted, but they are permitted to vote and their votes are counted. They go to the polls, they cast their ballots, they send their representatives to state councils. Their complaint is simply that the representatives are not sufficiently numerous or powerful. So they say, well, the citizens, they cast their vote, they go to the ballot, but their complaint is that there aren't enough people. It's not diverse or powerful or numerous in their choices in that regard. And furthermore, relevant constitutional principles at once put these appellants out of federal courts. Manifestly, the Equal Protection Clause supplies no clear guide for judicial examination for apportionment methods than what the Guarantee Clause itself. Apportionment by its character is a subject of extraordinary complexity, involving even after the fundamental theoretical issues concerning what is to be represented in a representative legislature have been fought out or compromised. Considerations of geography, demography, electoral convenience, economic and social cohesions, and divergence among particular local governments, local groups, communications, and practical efforts of political institutions, ancient traditions, respect for proven incumbents, mathematical mechanics, and loss of others. These are not factors that lend themselves to evaluations of a nature that are the staple of judicial determinations or for which judges are equipped to educate for legal training or experience or native wit. And this is the more so true because in every strand of this complicated, intricate web of values meet the contending forces of partisan politics. Apportionment battles are overwhelmingly party or intra-party contests, and it will add a virulent source of friction and tension in federal-state relations to embroil the federal judiciary in them. So basically what they are saying in this dissent is that the Supreme Court didn't want any type of participation in active politics, meaning that they were actually electing officials based on the fact of the lack of redistricting, and this will bring the Supreme Court into politics, which the Constitution shields them from that. And that's what the gist and the thought process of this dissent through Justices Frankfurter and Harlan. So, on to the next Supreme Court case, that in a most recent one, which is Shaw v. Reno, also known as Shaw 1, in 1993. And the facts of this case is that United States Attorney General rejected a North Carolina congressional reapportionment plan because the plan created only one black minority district. North Carolina submitted a second plan creating 2 black minority districts. One of those districts has a wider interstate road. 5 North Carolina residents challenged the constitutionality of this unusually shaped district, alleging that its only purpose was to secure the election of additional black representatives after a 3-judge district court ruled that they failed to state a constitutional claim. The residents appealed, and the Supreme Court granted certiorari. And just for your reference, certiorari is a writ or order by which a higher court reviews a decision of a lower court. So every single time someone or a party wants to bring their case to the Supreme Court, they will have to write a certiorari in which the justices will read that and decipher if their case meets the qualifications of a Supreme Court ruling. So just for your understanding of how the demographics of the North Carolina voting population was at that time, in this little pie graph here, it was 78% white, 20% black, 1% Native American, and 1% Asian. That was the population in the state of North Carolina. So the legal issue that was brought up to the Supreme Court was, did the North Carolina residents claim that the state created a racially gerrymandered district raise a valid constitutional issue under the 14th Amendment Equal Protection Clause? And the Supreme Court ruled that the North Carolina's reapportionment plans was racially neutral and resulted in weirdly shaped districts, suggesting that it constituted an effort to separate voters into different districts based on race. In result, the residents' equal protection claim was valid. The court added that in the absence of contradictory evidence, the district court would have to decide whether or not compelling government interests justified North Carolina's plan. And the dissent? Well, Justice White, Blackmun, and Stevens dissented, stating that there is no doubt that a state's compliance with the Voting Rights Act clearly constituted a compelling interest. The court warns that the state's redistricting effort must be narrowly tailored to further its interests in complying with the law. And that concludes these 2 Supreme Court cases in regards to redistricting and reapportionment. So I hope you enjoyed this video. If you liked it, just give it a like and subscribe, and I'll see you next time.